Good afternoon, everyone. This is John Cornwell. I'm the Marketing Director here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which is part of our Sophisticated Employer webinar series sponsored by the firm's Labor and Employment Law Practice Group. As the COVID-19 pandemic continues to turn our lives upside down, many of us are asking whether this is a new normal of sorts. So that's why we wanted to take time out today to discuss with our attorneys who are hearing from their clients what they're personally thinking about this situation, what they're hearing, and maybe answer some of the more commonly asked questions, plus anything you have all submitted. We want to thank everybody who submitted questions prior to the start of the program, and we're going to try to get through as many of those as our time permits. So I'm pleased to be joined today by three of Plunkett Cooney's Labor and Employment Law Practice Group members, Christina Coral, Laura Dinan, and Claudia Orr, all of whom you should be able to see on your screen. So wave, everybody. I can see you guys. So I'm going to be moving around way too much, so I'm staying off of camera today in the background. So they are all on the front lines of the COVID-19 response, in addition to all the other things they do from an employment standpoint for their clients. So we're glad to have them. As I always do, I like to just give a couple of bullet points about our firm in case folks don't know about Plunkett Cooney. We're based in Southeast Michigan, and we're one of the Midwest's oldest and largest law firms. And these days we have about 150 attorneys. We have 7 offices in Michigan, and we also have locations in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our employment law practice group includes more than 20 attorneys who work in all the different areas of employment law, including traditional labor, human resources consulting, litigation, and workers' comp claims. Our Sophisticated Employer webinar series, I think we're in year 9, if you can believe it already, for this series, and it's designed to help our human resource professional clients, our risk managers, and even business executives stay up to date on all the important issues in employment and to provide you with HR best practices when we can, and to discuss any trends that we're seeing in workforce management. So just a little bit about today's presenters. Christina Coral is the managing partner of our Columbus, Ohio office, and she serves as co-leader of the firm's Labor and Employment Law Practice Group. She also finds time to be a member of our board of directors. I don't know how you do it, but Christina has extensive litigation and trial experience defending employment cases in state and federal court. She represents numerous employers and has the distinction of serving as special counsel to the Ohio Attorney General for employment matters involving several academic institutions, including, and it's important to say, the Ohio State University. There's a thumbs up. Laura Dinan has over 30 years of experience advising employers. She's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Laura's expertise includes traditional labor and all types of employment law matters. She's a past president and currently the secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. Welcome, Laura. And last but not least, Claudia Orr has nearly 30 years of experience representing employers ranging from Fortune 500 companies down to small businesses and nonprofits. Claudia provides advice on all aspects of employment law and defends her clients in litigation and in administrative issues when they arise. She also regularly serves as an arbitrator and as a mediator in employment law cases. Claudia is serving as a member of the board of directors of Detroit SHRM for the second time around, and this time she's in the capacity as secretary. She also remains a member of the organization's Legal Affairs Committee. So now just a couple housekeeping notes, and we're going to jump right into the program. Today we're going to handle things a little different for those of you that have been with us on a number of other occasions. Throughout the discussion, we're going to be using the polling function within our GoToWebinar software. So we're going to try to mix in some poll questions as we handle some of the questions you've pre-submitted, and then you are also invited to please put in questions to our questions widget that's part of our GoToWebinar interface. And as I mentioned, we'll try to knock out as many of those as we can. We're going to give you, on the polling questions, we're going to give you about 30 seconds to respond. And don't worry, if you haven't done it before, polling in GoToWebinar only captures the group's percentage of responses. So your individual responses won't be shown on screen or even really available to us. So as always, the Q&A portion is going to use that questions area on the GoToWebinar display. So take a look and please try to find it now. You can put in your questions anytime, and I will do my best to get those worked into the conversation. Finally, I want to mention that today's session is being recorded and that we're going to make that recording available on our Plunkett County website on the events page. So you can check that out again if you want to, or share it with a colleague. They can simply go there, or you can copy and paste that link over to them in an email. So thanks again for attending today's webinar. We're going to get started, and since this is primarily a question and answer format today, I thought we'd start with opening statements from each of our panelists. And I think, Christina, we're going to start with you. And really, I would like to just get your thoughts on whether you think we're kind of in a new normal and maybe what your clients are thinking about.
Well, welcome everybody. Thank you again for coming to our town hall today. And we are all, despite what went on before you got on today with a few technical difficulties, I think we're all kind of getting used to this new technology. I think, to answer your question, John, I think there are portions of things that are going on right now that are going to be our new normal. I just learned yesterday that the largest law firm in the state of Ohio, which is actually the Ohio Attorney General's office, did not renew the lease on their offices. The entire Attorney General's office in the state of Ohio is going to work remotely from now on, which I was absolutely shocked at. I think that's one of the things that we are going to start seeing as the new normal, because people like it, right? So if you don't have to get out of your pajama bottoms during the day and you can still do your work, I think employees really like that. It's a benefit to some employers too, because it cuts down on a lot of costs, but it also, as we're going to discuss today, presents a lot of other issues that require oversight from employers. So I certainly think one of the things we're going to see as the new normal is a lot more places of business are going to be conducted remotely.
Thanks for that. Laura, over to you up in Northern Michigan.
Thanks, John. Hi, everybody. Glad you're with us today. I agree with Christina. I think big parts of this are going to be the new normal, but I also think it's kind of still evolving. And, you know, I don't think we're going to totally know what the new normal is until early next year at the earliest. I think that for now, people are kind of settled in, but next week, as schools start coming back into session, that is going to impact every employer, because every school district, every school building is handling it differently. And they have a plan, but when that plan goes into action, I don't think many of them are going to be able to stay exactly on track with their plan, because the disease is not predictable. And that means if the schools have to change plans, the kids change plans, the parents change plans, and that affects the employer and the workplace. So I think the remote work is here to stay. I know that many employers in Michigan aren't even planning to think about bringing people back until next year. And I think as time goes on and they realize how successful people can be, they'll be, as Christina said, many more people are just going to be remote employees. But that brings challenges. And I do think with the school year starting, a lot of those are going to come to the forefront. I think those are the primary questions I'm getting right now: how to apply the Families First Act and leaves and things like that. And hopefully we'll cover that for you today.
Great, thanks, Laura, for that. Claudia, over to you.
Yeah, I'm getting a lot of calls. Initially, it was all about the leaves of absences and the federal leave laws and so on. But what I'm hearing more from my clients at this point is that the workforce is going through a morale problem, that employees are feeling disconnected, their morale is down, they're stressed out, they're unhappy. I'm getting more grievances from union employers, hearing more from the union leadership about, you know, our membership's just not happy. And I think it's, and it's not just the clients either. I can actually hear it in the voices of you know, the HR people that I work with, that they seem more stressed and kind of down in the dumps too. So, you know, I guess that's one of the challenges, is how do you keep people engaged and excited about their job when they're feeling isolated or they're a little bit concerned about the future. So that's definitely a challenge.
Got it. Okay, so with that as our backdrop, we're going to kind of jump into things as best we can. And as I mentioned in my opening remarks, today's all about answering your questions, and we have a number of those to tee up. And we're going to cover a lot of waterfront, as you can imagine. A lot of these issues are intertwined. So we can do a little word cloud here just to try to capture some of the things that you all deal with on a daily basis. And baked within this word cloud are a number of elements that are dealing with the COVID situation. So today's discussion is going to focus on 4 different areas. One is back to school and all the areas that kind of go under that. Our next section is going to be back to work, when people are actually returning back to work. We have a number of questions related to that. The third segment of 4 is back at work. So some of the things that are going on with employers and employees back at work once they get there. And then last but not least, we're going to do a little bit of a miscellaneous or potpourri type segment to just try to wrap things up. So having said all that, I'm going to jump into the first question we have. And I'll have the panelists just kind of decide to field these as we go along. The first one has to do with I always get these acronyms, Families First Coronavirus Response Act, the FFCRA. So the FFCRA allows leave if the school or place of the child care is closed, or if your child care provider is unavailable due to COVID-19 related reasons. When is a school or child care closed, quote unquote, under the FFCRA? Who wants to
I'll
take
take
that
that one, John. Under the FFCRA, if the physical location of the school or the child care center is closed, then the school or place of care is closed for purposes of offering leaves for the paid sick leave and the expanded family and medical care leave under the FFCRA. That includes if the school is closed, but they are doing all online or remote learning. So if your child doesn't have the option to go to school, they have to do remote learning, then your school is closed for purposes of being able to take paid sick leave or the expanded family and medical leave. If the physical building is still open, I know a lot of school districts are giving options. The kids can come back in person or they can do remote learning. If that's the situation and the parents are opting to voluntarily stay home, then they are not entitled to the paid sick leave or the expanded family and medical care leave under the FFCRA for the child care purposes. They might still get the paid sick leave for illness reasons, but not for taking care of their kids if they are opting to keep them home, even though there was an option for them to go back to school.
Okay, great. Another related question, unless anybody else wants to add to that. The next question I see that's related to that, the FFCRA in childcare is intermittent leave available under the FFCRA for childcare purposes, such as caring for children in the after-school hours or on certain days of the week if a district has partially in-person learning and partially online learning, for example?
Well, I'll take that. It rolls right off of that one. This is a moving target. As the law was originally written and the original Department of Labor guidance, the employer was allowed to let employees use the expanded child care under the Family and Medical Leave Act intermittently, but it was the employer's choice, not the employee's choice. It wasn't really written into the act, but the Department of Labor opined that you probably, if the employer wanted to do it, it was fine. Then the Southern District of New York came out with a case a couple weeks ago that really kind of took apart portions of the Department of Labor guidance. And this was one area where they said that's pretty much ridiculous that parents if parents want to choose to use the leave intermittently, they can. That case is not precedent setting for us, but it's something to be aware of, and it's likely that if a case like that got to the Sixth Circuit, they're very employee friendly right now, and it's likely they would probably side with it. So employers have to be cautious. And initially, the Department of Labor was silent, but Claudia found last night that they came out with new guidance on this. You want to fill people in on that, Claudia?
Sure. Breaking news. Last night, the DOL sent out its revised FAQs, and one of the FAQs, the newly added FAQ says, my child's school is operating on an alternate day. The school is open each day, but students alternate between days attending school in person and remote learning. And so the question is, can they use their extended family leave or the FFCRA under these circumstances? And the Department of Labor said, yes, you are eligible to take paid leave under the FFCRA on days when your child is not permitted to attend school in person, must instead engage in remote learning. So, and they talk a little bit more about, they say the school is effectively closed and so on, but this is directly in contrast to the original, or I should say the final rule, the original final rule. And what it says is that the employer has to agree to this in the final rule. It's not like, yes, employee, you are eligible. Instead, it's yes, employee, if your employer agrees to it, you're eligible. So, I mean, the landscape is changing so often with these new federal leave laws. And so all I can say is the information that we're presenting today is current, but by tomorrow it may not be. And so when these legal issues come up, it's still a good idea to contact your attorney and ask for legal advice, because it may be different by tomorrow. So back to you, Laura.
I think, do we have another question in this area, John?
Yeah, we do. You know what I was going to do? If we could, let's take a moment to pause and do our first poll question, if that's okay. This ought to be interesting. So I'm learning this technology. So as you'll see here on the screen, let me launch this for you. What percentage of your employees, you know, I can't even see the whole thing now that I launched it. What percentage of your employees have asked for EFMLA for the fall term? So go ahead and click in your answers there. Hopefully you can all see that on the screen. I'm going to give you probably another 10 seconds here, and then we'll lock it in.
Yeah, and for anyone who's listening who's not sure, this is the extended family medical leave that allows the parents to stay home if their child's school or child place of care is closed.
Okay, well, it's pretty lopsided. I can see it here on my end. Oh boy. Anybody want to guess what we're going to get here? Let me go ahead and share this poll. I'll close it. You should see it on screen, so let me know if you don't.
No, instead we've got.
You got all your, hopefully your answers. 52% voted. I can see that on my end. Emma's sharing it right now.
There it is.
Oh, there we go.
There we go. One more click. Right?
Okay, so not too many people have asked for it. Only about a fourth of the workforce normally, or less.
Okay, so we're going to hide that. Hopefully we are back on our PowerPoint. All right, so let's move on. I have another related question, and it is, do we have to allow remote work to employees who are not entitled to FFCRA, but who have children at home that can't stay alone?
Well, legally, no, but you should have a really well thought out policy to address this, because you need to handle these requests on a non-discriminatory basis. If you pick and choose the employees that you allow to work from home based on their reason for wanting to be home, you could face a caregiver discrimination claim. You do not want, if it's a job-based reason to deny remote work, that's one thing. But if it's because, well, you know, Johnny only has dogs at home, so he'll probably be more efficient because he won't have kids bothering him, so we're going to let him work from home. But if you're staying home to work while your kids are going to school at home, that's not going to work out very well, so we're not going to let you do that. That is a minefield. A caregiver discrimination claim are typically filed by women accusing an employer of treating some workers worse than their colleagues because of their family responsibilities. So if an employer refuses to let a woman work from home to care for homebound kids, but lets men work for other reasons, you could be susceptible to such a claim. I know that some employers, and it's very size and location dependent, but some ideas out there, some employers are creatively assisting their employees who have either exhausted their FFCRA leaves or simply aren't entitled to it, with such things as giving them an unpaid, it would be unprotected, but an unpaid leave to take care of their kids. Some of them are doing temporary layoffs again, like we saw right in the beginning when remote work wasn't available for everyone. Some are doing flexible or reduced working schedules, like letting people work early in the morning and then later in the afternoon or in the evening, or working part-time, dropping their hours to part-time. It obviously is going to depend on the job the person does and whether you can afford to have them work reduced hours, or whether if it's absolutely a 9 to 5, 8 to 5 kind of job, it's not going to work out for them to do their job, you know, at 5 in the morning so they can be free when their kids go to school. So those are some ideas that are out there that can work for some employers, but the bottom line is you don't have to allow remote work if you don't allow it at all, or if the job is not conducive to it. But if you're picking and choosing, be very cautious about denying it to people who are asking for it to take care of their kids. I think that answers that one, John. Back to you.
Okay, we're going to do another poll. I find these fascinating. So this next one, I'm going to go and launch it here. What percentage of your employees are still working from home? So we want to have you lock in your votes there. You got 15 seconds. It's fast and furious. The voting is fast and furious. I got 70% voted already. Nice work, everybody. Okay, we're going to close this out and share it. And there you go. Would any of you care to comment on these results?
Well, you know, it's about what we expected, right? Because the governor's order in Michigan still requires employees to work remotely if it's possible. I think a lot of businesses right now are still defaulting to allowing as many people as possible to work remotely. So this was the fact that no one, right? Is that correct? No one has 100% of the workforce back, I don't think is surprising. Claudia or Laura, do you think differently?
I just think supply and demand, no one's buying gas these days and the prices ought to drop.
Yeah. Yeah, I'm in a different region. We're in stage 5, so we have the ability to bring everybody back if they want to, if an employer wants to. What I'm hearing is people are still gradually doing it. If people, a lot of them, I think most people have been staying home and maybe a day or two in the office. And I think when school starts up again, I think a lot of things are tied to the start of school. But I think at that point, a lot of employers up here are planning on bringing more people back into the office. If you're not in the UP or the northwest corner of Michigan, then I think the order is that you still must allow remote work if they can effectively do their work from home. Here we're in a should, but it's very flexible.
Okay, great. So we're going to move on. You know what? Unless you guys want to do one more poll, you guys in the mood for another poll? I think this next one's interesting. It might be related to some of the comments here. Let me do this one. This one is, how likely is it that the majority of your workforce will remain working remotely after the pandemic is no longer a concern? I think a lot of people in the commercial real estate business are probably holding their breath when they see a question like this. So it looks like we've got about 66% voted. So, well, what do you think? Anybody want to comment on these results?
I don't see them yet.
Oh, didn't come out yet?
No, not yet.
Here we go. Let me share. One more click. There we go. And share. There's too many clicks on this. Can we see them now?
Interesting.
Across the board a little bit.
I guess I expected that it would be more likely that a majority of the, well, I guess, you know, it just depends on the industry, right? So depending on what your industry is, remote work might be killing you right now. So, yep, I see that.
Okay. Let me hide that. We'll move on. Okay, our next topic area is kind of defined as back to work. And so the questions that were submitted ahead of time, try to slot these in. So the first one I have is, what can HR do when the CEO wants all employees back working in the office, even if they can and have been effectively working remotely?
I'll take that one. So take out of the equation any governors or other executive type orders or quarantines that require employers to allow remote work if it's possible. Okay, so take that out of the equation. If there's no such order in place, the reality is if you tell your employees to come back to work, with certain exceptions, I suppose, they got to come back to work, you know, unless they have a qualifying reason to stay home under one or more state or federal statutes. The reality is that folks have to start coming back to work. So I tell everyone sort of the same thing about this whole situation. We're in such new territory as human resources professionals that lots and lots and lots of communication is helpful at this point. I mean, sometimes you have topics that you don't want to talk about a lot, but this is one that people are scared. People are scared to come back to work. Other people just don't want to come back, right? They like working at home. So, you know, a communication with your employees is going to be absolutely essential. Barrage them with information, assure them that you have taken every step and precaution necessary to make sure the workplace is safe. And you're just going to have to be patient with people. You know, this is an unprecedented event in the United States, at least in our memories. And so you're just going to have to do an interactive process with your employees to assure them that it's okay to come back. But at the end of the day, when it's time to come back, they got to come back.
Okay, there's another question that was submitted ahead of time that kind of talks about this. So what can HR do when employees who do not want to return to work are needed in the office or workplace?
Well, like I just said, when it's sort of the same dovetail question, you know, when it's time to come back, you're going to have to come back. And unfortunately, employers are going to be put in a position, it's going to happen, that some employees are going to have to be terminated. If they don't have a legitimate reason, once everyone is coming back into the office, if they don't have a legitimate reason to continue to be working remotely, and the company has made a policy decision that folks need to come back and work in the office or in the warehouse or you know, wherever it is, employers are going to have to make difficult choices, and there may be some employees who will be terminated if they refuse to come back to work.
Today there was a question submitted on productivity, so I'm just trying to figure out where it's best to weave this in. So I'll ask this question that was submitted today. What are your, and anybody can answer this, what are your thoughts on forcing employees to work in person because their productivity is so low? It's
Claudia?
a different area there, yep.
Claudia, you're muted.
Can you hear me now?
You can hear me now?
Yes.
There we are. So yeah, I think that's a big motivator because, I mean, they're going to view it as a punishment. You know, it's, you know, if you're not productive at home, you're going to have to work in the office. But instead, the way it should be phrased to them is that I'm concerned that you have distractions at home that are preventing you from being successful and productive on your job. And so to assist you, we're going to return you to the office so that you can work from there and maybe get your productivity back up so you can succeed in your position. And, you know, eventually employees are going to get the idea, if I keep working like I'm supposed to and doing what I should be doing because I'm getting paid to do it, then, you know, they'll let me work at home. But if not, then I'm going to have to drive to work every day. So I usually like the carrot and the stick. I mean, you can also set the productivity goals and just, you know, you could give out bonuses if you can afford it. You can also have contests if your work site is such that you can do that and, you know, give out the grand prize each month and the second place or something. And people may get a little bit excited, especially if they have teams that are working towards it and get some peer pressure going. So, but yeah, I would return them to the workplace if they're not going to do what they're supposed to do working from home.
I feel another poll question coming on, so I'm going to ask it. This is a productivity one, so here it goes. So what happened to productivity when employees began working remotely? See if folks want to jump in on that one. They sure do. Give you about 10, 15 more seconds here. Please lock in your vote. I will do my best to get this sharing right this time. Okay, and the last couple are coming in. So we'll close it out. And I'm going to share the results. Same thing, panel. What do you think of these results about productivity?
Looks like the same or gotten a little bit worse for the most part.
Mm-hmm.
Well, you know, I wonder how much of that is related to just the uncertainty and decrease in business associated with COVID versus a productivity issue. We'll probably never know, but that's the thought that comes to my mind.
And you don't really know what's causing it either, just because it has decreased. I mean, it could also be like I said earlier, employee morale is down, or they're feeling disconnected, or maybe their work site is not set up as efficient. They've got kids running around, they're making their lunches or whatever. That could be a problem too.
Okay, so let me hide that real quick. Get back to you. So our next segment is getting folks back, having folks back at work. And Claudia, you kind of talked about this. So this question, you can just tell me if you think you answered it. It talks about employee motivation. So how can you motivate employees to reach productivity goals while they're at home working?
Yeah, I think I already covered that with the carrot and stick idea and bring them back to work if they don't.
I'm just trying to work through these, make sure I don't miss anything. Here's another one. What can you do when you think an employee is reporting hours worked that you think are inflated because they're watching small children, perhaps?
Well, I'll take that. It's related. You know, obviously you should be reviewing productivity and monitoring their work. Some IT programs are out there that will actually look to see if you know their keystrokes are constant during the day, or if there's long gaps. You can look at documents that they've been preparing in their emails to see if there's like a 2-hour period where there's silence, basically nothing but crickets. So sometimes you've got the technology that will allow you to look, but the other thing is some jobs don't necessarily require the person to be on their computer, so you can't just rely on what they're doing on their laptops to see if they're doing what they're supposed to be doing. I mean, for me, I'm responding to emails a lot, but I can also get on a call with the client for an hour, or I can be looking at documents, you know, out in the sunroom, and not really, you know, sitting in front of the computer. So, you know, there's really no way you can watch me. But so you don't really know. And so it's basically looking to see, are they getting their work done? Some of my clients are starting to move to, they're wanting to make their employees exempt so that they don't have to worry about tracking hours or overtime. As long as the work's getting done, they don't care when they're doing it. Other employers don't want to do that because they want core business hours where people are accessible and clients can reach them and so on. Just keep in mind that if you end up with exempt employees who are only working a portion of their day, it could be a discipline matter, but before you start docking their pay because you sense they're only working a half hour each day, you better, you know, talk to one of us and make sure that you're not violating the Fair Labor Standards Act rules. But if it's a child care issue, you can always look at whether or not they qualify for the family medical leave, the new leave aspect under there, where they could, you know, maybe work portions of days and take the other part of the days off, or, you know, if they've got child care in the afternoon but not in the morning, for instance.
Claudia, I think you're psychic, because I just saw a question pop up, kind of gets into this area, and it's this. So again, if you feel like you've covered it, let me know. But this is one that came in today. What are your thoughts on the Governor's Executive Order 2020-172 and being able to discipline an employee who shows a pattern of calling in sick with COVID-19 symptoms?
Laura, is this from the executive order you reviewed earlier?
Yeah, well, I think it would be the same as disciplining someone who you think is abusing your sick leave policy normally. I mean, the governor in Michigan, the executive order regarding protections for employees from retaliation, discharge, discipline, et cetera, was originally Executive Order 36, and then it was 166. And yesterday, last night, hot off the governor's desk, speaking of things changing on a regular basis, she issued Executive Order 172, and it's very similar to 166. The biggest change was a better definition of what the symptoms are. But in any event, there are protections in the order for very specific situations regarding COVID. And so if someone is repeatedly taking time off, not a block of time, for alleged COVID symptoms, first of all, I'd probably make them go get a test and see if they actually have it. I don't recommend across the board testing, but if you got somebody doing that, then I think it's fair to send them for a test and find out if in fact they do have it. And, you know, again, you know your employees, you know who's going to take advantage of situations. You're not, the executive order prohibits discipline for very specific situations, and it protects employees who actually test positive or have the symptoms. Let me see if I can just find the exact language. But they're protected and required to stay home for 24 hours after their fever's resolved without the use of fever-reducing medication, and 10 days have passed since their symptoms first appeared, or they were swabbed for the test that yielded the positive result, and their other symptoms have improved. That's the protection for someone who has tested positive or displays the principal symptoms as defined. And if the situation is they've been exposed to someone with COVID, they're required under her executive order to stay home for 14 days from the last close contact with the sick or symptomatic person. A close contact is 15 or more minutes within 6 feet or less of a person who's been diagnosed with it. Or they stay home until the individual who displayed the COVID symptoms that activated the 14-day quarantine period gets a negative COVID test. So those are the situations that are actually protected under the governor's order. So if it's outside of that and you're suspicious, I'd probably send them for a test and then treat them as you would anyone else who is abusing your time off policies.
Hey, Laura, I was going to add, I get calls from clients. They'll call up and they'll say, yeah, this employee was saying that he's not been feeling well, and he told us about some of the symptoms that could be COVID. And so he said that he got it set up where he will be able to take a test. You know, it's like Thursday and the weather's nice. A test next Tuesday when they're predicting rain. And he should have the results back by that Friday or the following Monday. And one of the things I've suggested to my clients is that you form an alliance with a testing place nearby that will give you a quick turnaround and allow you to schedule a test quicker. So don't let the employee pick the place that they're going to get the test and get it back to you when they feel like it, because they want some time off this summer. Instead, schedule it at a place that will get them in. You can send them right there. They'll get swabbed, and they run the test on site, and by tomorrow you'll know the results. Get your little bottom back in here. So
yeah,
don't let them pick it.
I totally agree with that. And just for your information, this new order from the governor defines principal symptoms as any one of the following not explained by a known medical or physical condition: fever, an uncontrolled cough, shortness of breath, or at least two of the following that are not explained by a known medical or physical condition. And that's referring to like allergies or a cold. Two of the following: loss of taste or smell, muscle aches, sore throat, severe headache, diarrhea, vomiting, and abdominal pain. I've had a lot of people say, oh, I've got an employee with a headache, they won't come to work because they think they have COVID. And so in the last order, they defined it as severe headache. Now they're breaking it down with one of these or two of these. So stay tuned to her orders. They really are helping clarify it, and it helps address these issues with these types of employees. And we don't have the quick, at least I'm not aware of the quick turnaround tests up here, but I know that there are a fair amount of employees up here who are concerned on their own when they're exposed, and some of them even driven to Lansing to find the quick turnaround test so that they can get that answer right away. So there are employees on both ends of the spectrum, but definitely the employer should be in charge of directing when and how they get those tests done in the most expedient way.
Driving downstate and exposing everybody along the way.
Well, yeah, there's that. But you don't have to get out of your car, right?
Except at the gas pumps,
Yeah.
get the can pop.
Well, I got a related question here. Do we have to pay employees for the 14 days they're at home under FFCRA if they're in close contact with somebody that is COVID positive or suspected COVID positive?
Well, if you qualify, if you got less than 500 employees and they've got some symptoms and they're going for testing, trying to get it diagnosed, or they're told to self-quarantine by the doctor because they've got the symptoms, then I mean, it doesn't cost you anything. You're going to be able to take it off your payroll taxes, get a credit for it. Just make sure you get the documentation to support the tax credit. But yeah, you're going to have to pay them, and you can't force them to use their PTO instead.
Okay. Before we move on to our kind of miscellaneous or potpourri round here, I wanted to get one more poll in if we could. So I'll go ahead and launch this one. This is one last poll. It's about working from home. I had it teed up here, so I wanted to see if we can share that. Go ahead and lock in your votes on this one. Okay, we'll give you about 10 more seconds. Okay, we'll wrap that up. We're going to close it out and share that result. So what percentage of your employees have asked to continue to work from home? Any thoughts there to our experts?
Well, I'm not surprised that people want to.
Yeah, I would think.
Yep, I agree.
Yeah.
That's why
Okay.
telling them if they don't improve their productivity, they'll have to work in the office where there's less distractions is quite
effective.
a motivator. We're just trying to help you.
Right. Okay, we'll hide that. Let me go back here, and I'm going to show my screen again. And here, so we're gonna move on to our next segment. Like I said, we're gonna have this. We kind of call this, miscellaneous. And I guess, Christina, this would probably be a question for you. What can or should an employer do about employees whose customers bad-mouthing employers for either enforcing people to return to workplace or appearing not to be taking adequate safety precautions?
So this question implicates the employment lawyer's worst nightmare and also sometimes best dream, social media, right? So you always have to be careful. Employees are legally protected to discuss the terms and conditions of their employment with other employees and the public. That's enforced by the National Labor Relations Board, which was an entity that was originally formed having to do with protecting an employee's ability to talk about and form employee unions. But the reach of the NLRB has been extended and has gone way into, employers' policies, monitoring of social media. You have to be extremely careful as an employer about monitoring your employees' social media. I know a lot of people do it. I have employers call me and want to tell me about it, and I plug my ears and say, no, don't tell me any of that, please. But so you have to be very careful. So this is what I tell people, and it goes to customers too. It really does. You can head off a lot of this type of off the record bad mouthing if you're talking to your employees, like we talked about earlier. If you're keeping people informed, if you're assuring people that you are taking all of the required safety precautions, if you demonstrate that you're following the law, you can head off a lot of this stuff. So what do you do when it happens? So this is always a case-by-case analysis for employers. Sometimes I tell employers don't do anything because, as we all know, especially with some folks on social media, if you jump into the fray, you just make things worse.
Poke the bear.
Yeah, so sometimes I advise my employers, look, this too shall pass. Just ignore it, let them get it out of their system. I sometimes advise people to contact directly, instead of jumping into the social media fray, contact directly whoever is complaining and see if you can one-on-one with them over the telephone address their concerns. Or, depending on what it is, if it looks like it's more widespread within your workforce, call a meeting at the office. You don't necessarily have to talk about the fact that you're calling the meeting because of the bad mouthing online, but you can call a meeting and talk about the concerns that the employees have. Many times if you just let folks talk and get it out of their system, you can head off worse problems down the road. But these can be thorny issues, and I always tell everybody there's no one-size-fits-all answer for these questions. It's going to be a case-by-case analysis that you're going to have to discuss with your administration, not just human resources, but the administration, because it has big implications today because social media is so powerful.
Yeah, the other thing in Michigan you have to be careful about is the social media privacy statute. So, if it's a manager who's a friend on Facebook and that's how they learned about it, they were in the back pages, the confidential pages, and saw something and they're the manager. The question becomes, did they send the friend request to their employee? In which case, are they high enough in the company that this is the employer asking for passwords or access to the private pages? So I always make sure my employers tell their supervisors and managers that they can't be friends with anybody who is working for them, and to defriend them. And then also if they say, we've heard that somebody's posting things, it's like, well, stay off their site. And I have a site that I use solely for the purpose of spying on potential plaintiffs. And so I look to see what they're up to. And if there's anything, they trust, my clients trust me. If there's anything that they need to know about, I'll let them know. But otherwise, it's like, it's best that they don't know some things.
Great. I have a question that just popped up, and this is related to a positive test today. An employee's daughter tested positive today, and the employee immediately left to get himself tested and is negative. I don't know how quickly you can get that back, but apparently he's negative. His daughter will be quarantined 7 to 10 days per the instructions he received. And the question is, can I allow the employee to return to work on Monday as long as they remain asymptomatic?
I wouldn't. And besides that, if he got his test results back that quick, it's probably one of those rapid tests, and they have a high level of false negatives. And he's been living with this person in close contact. So whether, is it a false negative? Has the virus just not circulated enough that it's reading it? But he's definitely been exposed, close contact. I wouldn't let him back.
I wouldn't either. I think under the governor's order, he's required to stay home for 14 days.
Yeah, so hopefully you can get the documentation you need so that you can get that payroll tax credit for paying him while he's off.
Okay, cool. Another question here. Laura, I'm going to throw this one at you, and you tell me if you're okay with handling it. What potential liability claims should an employer be concerned about?
Well, we talked a little bit about the caregiver claims, which, I think the biggest claims we're going to see coming out of the coronavirus are retaliatory type claims, retaliation for people who don't want to come back in the office, wrongful discharge in violation of Michigan public policy, those types of claims I think we're going to see. Violation of Michigan's Whistleblower Protection Act, and they're all kind of linked in. Claims, if you have employees who file a complaint with MIOSHA or OSHA, we don't think there's going to be significant investigation of every claim that an employee files, because frankly, they're all underfunded and they're not going to have time. They're going to save it for safety violations, serious
deaths,
complaints that probably, deaths, and safety violations, probably like, in the meat packing plants are a good example where people are complaining and it involves hundreds of employees and they're going to go in and investigate those. But if you have one employee who says that they think their coworker sits too close to them, I don't think that MIOSHA is going to show up and investigate. But the problem is, once these employees make these complaints, you have to be hypersensitive to the fact that they made the complaint, because they are setting you up potentially for a retaliation claim. So any negative actions that you take against them, regardless of why, they will associate it with the fact that they complained to MIOSHA or OSHA, so, or any other agency, Department of Labor, whatever it is. So I think the retaliation factor is going to be the primary type of claims we see coming out of here. And I think every employer has to be very sensitive. And, you know, you're supposed to do the analysis before you terminate someone, whether it's just cause or not, even if you're an at-will employer. But I think you're going to have to stop and think about what this employee has been involved in, any complaints they've registered, how they've approached this whole new world that we're in before you even take disciplinary action. I think you're going to be able to discipline people still for sure, but you need to really stop and think it through to avoid setting yourself up for a retaliation claim.
Yeah, we might also get claims for failing to grant a leave of absence. I mean, just think about how the rule interpretation of the law has changed over time. You know, I've got companies that are healthcare providers, the companies are. And that case that you were talking about earlier, Laura, about from the Southern District of New York, that was one of the areas that they struck down. The final rule from the DOL said that if the company was a healthcare provider, that its employees, you know, were kind of exempt from being permitted to take those leaves of absences, or you could deny them. And then the Southern District of New York said, no, that's far too broad. When I read it, I thought the rule was too broader than the statute. But, you know, they said that it's actually, you look at what does the employee do, not what the company does. So, for example, you run a hospital under the old interpretation of the DOL, or the one that's currently out there. No one at the hospital had an absolute right to take a leave of absence. On the other hand, under the Southern District case, it's like the secretaries get to take it, the switchboard operators get to take a leave. So the question becomes, what's our Sixth Circuit going to say when they get their hands on it, when it's challenged? So we'll get to see. Nate. Hopefully it won't be one of our clients that's the test case.
Hey, John, I know we're getting sort of toward the end of our time. I want to make sure we got that unemployment.
We lost you, Christina. Can you?
I know we are getting towards the end of our time. I want to make sure we answer that.
I don't know if it'll clear up in a second. I know.
John, we can hear her. You just can't.
Okay, I can't hear you. Go ahead, Christina.
I'll jump in, Christina.
I want to make sure that we get to that unemployment compensation question that came in this morning.
Oh yeah, we can. Go. Yep, we sure can. Let me make sure I got it. Is this the one about the work share program?
Yes.
Yep, that's the one. Okay, yeah, there was one that came in today. And the question is, are there any options to help me avoid laying off workers? Great question.
Okay, State of Michigan Unemployment has a work share program, and I think that many of you probably are familiar with it, but it's been greatly expanded during the COVID era by executive order, and it allows an employer to reduce an employee's hours and lay them off for a certain percentage of the week through this work share program, and the federal government is picking up the tab for those hours at this point in time. And the work share program has always existed for employers, but under Michigan's statute, if an employer used the work share program, the hours that were on unemployment got credited back to the employer's account, and so it did affect your experience rating. But under the CARES Act, any work share hours that are paid through unemployment through federal CARES Act dollars, which is all of them if it's COVID related right now, are not going to be credited to your experience account. Normally it is, and if you're doing work share for another reason, not COVID related, it would still go into your experience rating. But if it's from April to December of 2020, work share hours paid out under the CARES Act, then it will not affect your experience rating. And someone asked that question this morning, so we wanted definitely to cover that.
Okay, great. Thank you for covering that. There's and we're right up against the end here. I don't know if maybe we can extend it just a little bit longer if you're okay with that. There's another question that just came in. So let me just try to get through it. Under Section 5 of the Michigan Executive Order 172, does an employer have to allow an employee to stay home for the time limitations if the employee has been exposed to someone with COVID-19?
No, under the executive order, they're not allowed to let them back in the workplace. And if an employee wants to come back to work or voluntarily comes back in violation of the order, then they're not protected from discipline or discharge. The order doesn't apply to them if they don't follow the rules, and the rule is stay home for 14 days.
Okay. Hey, Claudia, there was a follow-up. You had mentioned something about, at one point in the conversation, about the use of PTO. Could you just, if you recall that moment in the presentation, you had said something about not forcing employees to use PTO?
Yeah, if they're eligible to take leave under the new federal leave laws, you can't force them to go through their PTO first before they're permitted to use the federal. Plus, I don't know that you'd necessarily want to. I mean, the federal money, you know, they're going to get a tax credit back on it anyhow. I know there's productivity. Now they got the PTO plus the 2 weeks off, but still.
Gotcha. Thank you. I had one more poll question I want to ask, because there's a lot of conflicting information out there. As you can tell, I like my polling. And this one, we're gonna do this final poll question, and I'll wrap up with any closing remarks from the panel, and we'll get you off the line here. So let me launch this. It's simply the number of COVID positives maybe in your workplace, and this is anonymous. Remember, we're just trying to get a sense for how prevalent this issue is in our regions that we cover. So just wanted to get that out there to folks. We'll give you another 10 seconds or so to lock in your votes. But from what I can see on my end, it's a bit of an issue. So go ahead and finish voting. Go ahead.
Christina and Laura, I think we've created a monster, John, with these polling questions. If we ever try to take that toy away from him, it's going to be
you're
tough.
In trouble. Well, here, so take this. Here's my sharing
Oh,
result
wow.
right there. Isn't that amazing?
I didn't expect that.
I didn't either. Yeah. Wow.
Really high. Wow.
Yeah, I'm glad we got that, snuck that one in there, right? Oh, man. Well, I want to just kind of wrap things up. Let me kind of get to my, close this out and get all of your shining faces back on screen. I'm going to move on. We've covered as many questions as we can. You've got our panelists' contact information there. You can always reach out to them. They're always happy to chat with you as best they can to answer questions and kind of keep you out of the weeds on these issues as best they can. So I want to just wrap up today's discussion by letting you know that we're going to have a post-webinar survey pop up when we log off. Please take a minute to respond to that. We really value your opinions and any topic suggestions you have for future content. We'd take that into consideration. The recording for this program, again, is going to be on our website, the event page. Share it with any of your colleagues that maybe couldn't join us. We really appreciate you passing the word along. And we leave this material out for the long haul, so feel free to share that around. We really appreciate it. And if you would like to follow any of the firm's blogs that are out there for this particular practice group, our sophisticated employer blog is there on the website as well. If you would like to stay up to date on all the latest, we do a really nice job, in my opinion, in particular this area, putting out regular updates on this area of law. And on behalf of our panelists, that's it. We are done, and thank you so much for being here, and have a great rest of the day.
Bye.
Bye.
Yep. Thanks, everybody, and stay safe out there.
Aye.